Welcome to this special episode of the ECGI podcast. I am Amir Licht. I'm a professor of law at Reichman University and the editor of the ECGI Working Papers in Law series. Today, we have with us Professors Luca Enriquez from Bocconi University, Matteo Gatti from Rutgers Law School, and Roy Shapira from Reichman University. They are the co-authors of the article, How the EU Sustainability Due Diligence Directive Could Reshape Corporate America. The article was published in the Stanford Law Review. It was also selected to win the prize for the best paper in the ECGI Working Papers in Law series for 2025, which is sponsored by the WRDS. Luca, Matteo, Roy, congratulations. Well done. And welcome to all three of you. Your paper highlights a connection between regulatory interventions in the EU and private litigation in the US. That's a truly transatlantic approach. It's also an unusual combination, right? It's very European on the one hand and very American on the other hand. How did the three of you end up working on this together, and who spotted the connection first?
So I will take this one. This is an ECGI story. When after the proposal for the Corporate Sustainability Due Diligence Directive was published, the ECGI co-organized with the Stockholm University an event, a webinar on the proposal. And Matteo was also in the audience. And as it often happens in these cases with your friend during a webinar, you will exchange WhatsApp messages commenting on what we were hearing. And something that struck us was that not only this would apply to US corporations, but it would require them to comply with international conventions on labor that had never been ratified. So that was the first thing that struck us. But then immediately after, we also thought, well, but in the US, you have a duty of oversight for directors if a company is fined, and that can be also abroad, then shareholders can sue and recover from directors or anyhow bring suit for damages. And that's something that doesn't happen as often in Europe. So this discrepancy, this different framework made us curious of the implications. We wrote a blog post. And after that, Matteo had the great idea of asking Roy whether he would like to join us to write a paper together on this topic, because Roy is the master of the duty of oversight in Delaware.
So please explain to us the two sides of this interaction. How do American oversight duties affect the European directive? And how does the European directive affect American oversight duties?
Okay, so I will take this one because it's the more technical, but just promise me you won't WhatsApp each other while I'm doing it. So far as Luca just told us, we have this very ambitious EU ESG legislation, and it's ambitious in depth, it's ambitious in scope, but the question is not how ambitious it is on paper. The question is how it will be enforced on the ground, because this kind of legislation, it takes a process-based approach to regulating corporate behavior. It doesn't mandate specific outcomes. It mandates means, and it doesn't even require specific means. It just requires that company, like in general, put in place those risk management policies and procedures. So legislation of this ilk, they run the risk of turning into an exercise in box ticking, meaning cosmetic compliance. So to satisfy these process-based requirements, companies will pour resources into having nice sounding policies on paper, but they will not really change how they say behave towards the environment. Unless in this kind of legislation, there is a credible threat of enforcement, unless there is a channel for holding top corporate decision makers accountable if they don't take sustainability seriously. And the early versions of the directive, when Luca and Matteo just started talking, it included a direct liability provision, meaning that it imposed the direct liability on the directors for sustainability due diligence. And these provisions were taken out in the final version that was adopted as part of the political compromise. So the directive ended up only discussing sanctions at the company level. However, and that's probably the key point in the article, corporate fiduciaries, they still face a threat of liability when the companies don't comply with sustainability due diligence. It's just that they face this liability through an indirect channel, which is corporate laws oversight duty doctrine that Luca just mentioned. And so if you're a director in an American company operating in Europe, it means that American corporate law, Delaware corporate law probably, will dictate the tone at the top regarding the sustainability directive in your organization. So that's the first part of the equation. That's how American oversight duty doctrine affects the EU directive. The second part of the equation, how the directive affects the scope of American oversight duties, is that so the oversight duty basically it asks directors to be proactive about compliance. They cannot just sit there and wait that problems will be flagged to them. They have to install a system that monitors the issues, and they have to address red flags that the system generates and escalates to them. And these oversight duties, so-called Caremark claims, they enjoyed a real resurgence starting in 2019, over 5 or 6 years. Became from kind of irrelevant to one of the most relevant claims in corporate law. But until that point, they've remained largely irrelevant in the specific context of climate and human rights problems. And we argued in a paper that the directive could change that. And this European directive affects the scope of American oversight duties in several ways. Let me just mention two, and I'll be done. So one way that it affects it is through so-called information system claims, which means that the CSDDD changes the nature of human rights and climate issues from kind of a nice to have, largely discretionary issues, to central legal risks, from a business risk that the directors can choose to take to a legal risk that they cannot afford to ignore. So, for example, Luca mentioned the fine. The directive includes a provision about exclusion from government contracts. So say that the company doesn't take the directive seriously, and now a European member state doesn't renew the contract with their American supplier. It's a big loss to the American supplier. And when the case will come to court as a derivative action, the court is more likely to fault the directors of the American company, not just for what they knew about adverse human rights and environmental effects in the supply chain, but also for what they didn't know. So in other words, boards will have to put those issues on their agenda. They will have to proactively ask for information about how their suppliers treat human rights and the environment. One last thing, that aside from elevating those issues to the board level more consistently, the directive increases the chances that the board will receive actionable warnings, meaning red flags about human rights and environmental risk in your supply chain that you cannot afford to ignore. Part of it is because the directive effectively transferred the responsibility for all those numerous human rights and climate issues from sustainability departments or CSR departments to compliance departments. And compliance departments have a much more regular channel, report more regularly to the board. And because the CSDDD instructs each EU member state to appoint a dedicated regulator, a supervisory agent, to monitor companies' compliance with the directive. And so if you think about it, if we go 2031, something bad happens. I'm an American plaintiff attorney. I'm trying to gather information about what directors knew and when they knew it. I'm bound to have reports of that dedicated, say, German supervisor, French supervisor, Italian supervisor, reporting, documenting to the company, listen, you have a problem with supplier X, you have a problem with supplier Y. So the regulator flagged this behavior in real time. How come you didn't do something to address that?
You next argue that this CSDDD Caremark combo, so to speak, should make us rethink the Brussels effect. I mean, by the Brussels effect, we usually mean the ability of the EU to shape how non-European companies behave. So how is this Brussels effect different in our case?
Well, when we think about the Brussels effect, we usually think about it as a policing specific product attributes. And so it is easier to not let a certain product enter the EU market. But now the directive seeks to change the production standards themselves. So instead of what product you're selling, The EU now is regulating how you actually produce. And so this is something that is much harder to enforce because everybody can say we conducted due diligence, which is why the directive hinges on accountability mechanisms that come elsewhere. And the specific instance we focus on is corporate law litigation and US styled corporate law litigation. And so the robust enforcement of oversight duty can create a Brussels effect even in the production standards, simply because it makes directors set a certain tone at the top.
Now I have a little bit of a delicate question, so to speak. I mean, since you wrote the paper, there have been political developments of both sides of the Atlantic, right? I'm thinking mainly about President Trump in the US and the omnibus bill in the EU, which aims to lower regulatory burden, right? Would you say that these developments impact your core thesis? Has the world changed for you, for the paper?
We say that it made us re-edit the paper so many times. So that's the downside of writing a paper on something that is so topical. So precisely because the CSDDD promised to be so influential, we had all those pressures. Maybe I'll let Luca and Matteo speak to the pressures at the EU level, and I'll just jump in to add a sentence on the internal Delaware viewpoint.
So what happened from within was that the EU started being concerned about its competitiveness vis-a-vis China and the US, especially when it comes to innovative industries, tech, basically. And they commissioned a report to Mario Draghi, the former ECB president, chair. And Mario Draghi came up with a number of suggestions on how to make the EU more competitive, more innovative as an economy. And unsurprisingly, he also targeted over-regulation as one of the issues. So that the story is always that the US are good at innovation and the EU is good at regulation. And so it came out with the idea that a number of rules that are part of the EU acquis had to be reconsidered. Among them were rules on sustainability more generally, the ESG rules that had been put in place starting in the 2010s with sustainability reporting. That is intuitively a costly exercise for companies, and the scope was quite wide. It also caught medium-sized entities. So the recipe was to deregulate in this area, and the CS Triple D became one of the targets of this exercise that the European Commission undertook, which led in February this year to some significant amendments to the directive, especially when it comes to the scope and the subjective scope. So now, basically, it used to be the case that if you were a foreign entity operating in the EU, it was enough to have 450 million euro of turnover. Now is 1.5 billion, which, according to estimates, will lead to 1/3 of the company that would have been included to be actually subject to this rule. But it's still 300 major global companies. That must mean quite a high number of US companies, as you can imagine. So on that, nothing much has, so something has changed, but it doesn't make our paper irrelevant. There have been other changes, like there is no longer duty to have a transition plan and to implement it, or rather to report about it. This may be relevant for Kermer duty, for messy claims. And so we think on this particular, from this particular perspective, the paper is still relevant. There have been other attacks on our combination thesis that Roy and Matteo may want to say something about.
Matteo,
Yeah, so
Roy?
as Amir mentioned before, of course, Trump administration, massive reversal on policies on all things ESG. But also congressional Republicans have been paying attention to this. There's Senator Bill Augerty from Tennessee introduced the Protect USA, full capital, Act, which seeks, to shield the U.S. companies from the directive. How? There's a natural downright prohibition for certain U.S. issuers from complying with any foreign sustainability due diligence regulation. So, the proverbial, being between a rock and a hard place, right? Whatever you do is a bad decision. That is sitting on the Senate, and there are low chances it's going to pass, according to gurus on legislation passage in the U.S. As of earlier today. But it's still there, and for sure, there's been a lot of pushback, not just from politicians, but from lots of interest groups. U.S. Chamber of Commerce was very active in trying to push the directive when it was being negotiating, and then having the omnibus passed. So again, lots of pushback from the U.S.
Yeah, maybe I'll add just the Delaware angle. So, I mean, as you mentioned, this is a paper about the combination, like a combination between what happens when the Brussels effect of EU ambitious regulation meets the Delaware effect, kind of a, let's call it, vibrant private litigation environment. And both Luca and Matteo spoke to the pressures to dilute the Brussels effect. In 2025, also just several weeks after we published this draft, there have also been efforts to, maybe I want to say, water down the Delaware effect, in the sense that the Delaware legislator passed SB 21, and it changed corporate law and Delaware corporate law in ways that could affect the dynamics that we discussed. There was specifically that legislation, SB 21, narrowed shareholder inspection rights in a way that could potentially affect their ability to bring Caremark claims to hold insiders accountable for failures of oversight. You could say that it's harder to hold insiders accountable when you as an outsider have access to less types of internal communications. But relative to the changes that Luca and Matteo mentioned, we think that it's less problematic in a sense of less chipping away at our core thesis, as you mentioned, Amir, because for two reasons. First, in these kinds of claims, they are fed by information from foreign regulators. So as I mentioned like 5 minutes ago, if I'm a plaintiff attorney, I will have this kind of information subsidy, which is the European regulator already did the digging for me, already created the record for me, and I could then use it in my pleading stage. And second, in these specific cases, as opposed to other corporate law cases, it is the incentives of the insiders to provide as much information as possible, because this is a claim about what you didn't do. And if you don't show me that you put the issue on the agenda and that you responded to red flags, you may be faulted, at least at the pleading stage, for not doing so. So the narrowing of inspection rights are kind of less troubling for our purposes in these specific type of claims.
Looking forward, when the dust settles over changes to EU ESG legislation and competition between Delaware, Texas, and Nevada kind of decreases, maybe, do you have any forward-looking takeaways? I mean, for instance, what should academics or practitioners look at in this field in the next, say, like 5 years? What would you think?
We can take for granted that there's a big divide right now on ESG issues between the EU and the US, and we can expect it to continue, if not for path dependence. But these will continue to be some of the most important corporate governance questions that we have. And even with all the pressures that we've just described of watering down, the body of ESG legislation in Europe as is represents a marked difference, and so can create different market standards, and that would apply to US corporations.
Luca, Roy, happy with Matteo's response, I suppose.
I can add just half a sentence to Matteo's response, and then Luca will give us the bigger picture. So the half a sentence addition is that As Matteo said, we discussed one specific combo, like CS3D Caremark or Brussels Effect Delaware, but this divide between different countries, different markets on ESG issues is only going to continue to grow, and those interactions between how a certain country treats certain ESG issues and whether it becomes market standard or not for institutional investors could also be a matter of a cocktail of, China, EU, or China, US, or EU, China, and so on and so forth.
I will only add one component of specific EU law, which is that this directive, like most directives, will have decentralized enforcement, and therefore the issue will be whether there will be uniformity in the intensity of enforcement, and likely that will not be the case because different governments will give different priority to sustainability. You can expect right-wing populist governments not to be very keen on enforcing this. And so there's an additional discrepancy between the EU and the US because European companies may engage in regulatory arbitrage to some extent. They might choose in which jurisdictions to be subject to these rules by reincorporating, and that's now relatively easy in Europe. A US company would not have that choice because the criterion there for which supervisory authority is in charge is where most of the main turnover is made around the EU. So you are stuck to where you sell your stuff, and it's a bad jurisdiction. So from your perspective as a corporation, then you will have to suffer the consequences, which might not be the case at the margin for European companies.
Oh, that's great. By way of conclusion, I would say that the paper is like a great reminder that corporate governance today is like a cross-border phenomenon. You did a marvelous job in making this point. I encourage everybody to read the paper. It's available on the ECGI website and the Stanford Law Review website. The paper is also a great reminder that the ECGI is, practically speaking, the GCGI, the Global Corporate Governance Institute. And I think that's why the board of the ECGI Papers in Law series selected this paper for the prize for this year. We would like to thank our sponsor, the Wharton's Research Data Service, UIDS. This is the platform that aggregates over 600 databases from over 60 data vendors with over 550 terabytes of data. One might say that it advances comprehensive thought leadership by allowing users to analyze complex data and develop academic research. With that, guys, I would like to thank Elaine McPartland from ECGI, who facilitated this podcast, and you, Luca, Matteo, and Roy, for joining me today, and congratulate you for a well-deserved prize. Well done, guys.
Thank you.
Thank you.
Thank you.
Thank you.